to make these webinars very succinct and to keep them within that 50-minute time frame to allow for just sort of that lunch break opportunity. On occasion, because we do plan and we factor in time for a question and answer period, on occasion we don't fill up that full 50 minutes. We are under strict requirements with the CLEs that if it doesn't fulfill the full 50 minutes, we can only provide a half of a credit. So just keep that in mind as we go through this to perhaps encourage folks to ask their questions. Mark has agreed that the material is set up in a way that questions should be answered as we go. So if you have a question, because we have everyone on mute because of the level of attendees, please make sure you put your questions into the chat box on your screen. And I will be monitoring them as we go and interrupting Mark as we go to answer those questions. Having said all that, I'd like to thank Mark Wattenberg for agreeing to present this today and pull these materials together for us. I turn it over to Mark. Thank you.
Thank you, Becky. I'm a housing attorney at Southern Tier Legal Services in Bath, which is part of Law New York, which covers 14 counties in western New York. And I started my first bankruptcy in prehistoric times, the mid-1970s. As I remember, it was a family with 12 children, and I've been doing bankruptcies off and on ever since. Bankruptcy is a distinct type of court. It's a court where the judges are very interested in the law, usually very sympathetic to poor people, to people who are having economic problems, very detail-oriented, and as a rule, it's a great pleasure to practice in bankruptcy court. This afternoon, what we're going to talk about mostly is bankruptcy as a tool in foreclosure defense. And when a client first comes in on a foreclosure case, what factors you should be considering on whether bankruptcy might be a good option for that client. I'm going to talk about Chapter 7 and Chapter 13, the basics of those two chapters, and also whether bankruptcy makes sense in comparison to the standard modification process in state court. And part of whether bankruptcy makes sense involves factoring in the objectives of your client, whether it's to preserve the home or to give up the home but cancel the mortgage loan debt and get off to a fresh financial start. There are two basic types of consumer bankruptcies, Chapter 7 and Chapter 13. Chapter 7 is probably what most people think about when they hear the word bankruptcy. That's pretty much a straight discharge of the debtor's debts, especially the unsecured debts. And it's a process that's relatively quick. It usually goes 4 to 5 months. In a Chapter 7, the homeowner has the option. They can reaffirm, that is, honor the mortgage, or they can decide to discharge the mortgage, in which case they'll lose the house, but at least they won't face financial problems as a result of discharging the mortgage. Chapter 13 is a little different. Chapter 13 is a type of bankruptcy where you basically propose a repayment plan aimed at the bank and other secured creditors. And the Chapter 13 can go up to 5 years. Chapter 13 is often a good means of preventing foreclosure or a tax foreclosure for somebody who's had financial problems but is now stabilizing. Before I begin talking about Chapter 7 and then Chapter 13, I'd just like to mention a couple items about bankruptcy in general. Bankruptcy courts are part of the federal court system. I have practiced only in the Western District of New York. In addition, for upstate, there's the Northern District in Albany and Syracuse. The practice in the New York City and metropolitan area, the Eastern and Southern District is much different. And in some ways, very attuned to bankruptcy as an option in foreclosure cases. The bankruptcy courts have great websites. The websites, in addition to containing calendar information and local rules and so on, contain lists of the judge's decisions. And bankruptcy judges love to write. And so there are dozens and dozens of decisions from each of the bankruptcy judges, which make for very entertaining and informative reading. And also, if you're interested in admission to bankruptcy court, and you do have to be admitted in bankruptcy court in order to practice, the websites describe how you can get admitted. You first have to get admitted to federal court, but it's a very simple procedure. It usually only takes a couple months or so. And then one other feature of bankruptcy is, along with the federal court system, it's an electronic filing system. So you have to be able to file your pleadings electronically, and as part of the admission process, there are tutorials on how to do that.
Mark, we have a question.
Yes.
Ian has asked, why would a client reaffirm a mortgage in Chapter 7?
You would reaffirm the mortgage in order to be sure that you're able to keep your house. Now, if you do not reaffirm the mortgage, you could continue to make payments to the bank if the mortgage is discharged. And as long as you keep up your payments, the bank would not be allowed to foreclose. But if something happened down the road and you had not reaffirmed the mortgage, it might be more difficult to work out something with the bank.
Mark, I asked this question, I think, knowing that you're covering it later on, but maybe you can just keep it in the back of your mind, in that many of the banks, when we have homeowners that have gone through a bankruptcy, the lenders are saying that they won't offer modification at all unless they reaffirm that debt, which, as you know, can be quite scary, the notion that you can never get out from underneath a debt that you have reaffirmed after a bankruptcy. So maybe you can address that at some point in your chat.
Well, it might be worth talking about now a little bit, because even though you file a bankruptcy proceeding, you can still seek modification. You can seek modification during the bankruptcy process. Under HAMP, for instance, there's a section of the HAMP manual which indicates that borrowers can seek a HAMP during the bankruptcy process. And all of the federal agencies like FHA and Fannie Mae and Freddie Mac in their manuals, they talk about how a borrower in bankruptcy is still eligible for modifications. And part of the national mortgage settlement, which involves the 5 major lenders, Wells Fargo, Citi, Bank of America, and so on, those banks had to agree that they would accept modification applications from people in bankruptcy. So this is kind of an unexplored area, but it should be possible for a debtor who needs bankruptcy to file the bankruptcy, and if the debtor needs a mortgage modification through the bankruptcy process, to seek that modification. So I don't think it would be proper for a lender to say, unless you agree to reaffirm the mortgage, we're not going to consider a modification.
Right. We have a slew of several other questions here. If you don't mind me keep going, Mark.
Yeah, go ahead.
The next one says, is it true that the reaffirmation agreement must be signed prior to the discharge?
That is true, yes.
Okay. And then we have 2 more. The question is, they are already protected under bankruptcy, so why would they reaffirm if they cannot pay the mortgage?
Well, you would reaffirm. I think we're talking about a Chapter 7.
Yes.
If you want to save your home, if you don't reaffirm and you don't make payments, then once the bankruptcy discharge has been issued, the bank could proceed with foreclosure. In bankruptcy, you're discharging your personal obligations. You can't be sued any longer for debts that you have. But a Chapter 7 does not affect liens. It does not affect the mortgage lien. If you have a car loan, the UCC lien on the loan remains in effect. You may not owe the finance company any more money, but the finance company can take the car. If the lien is still in effect, and it would be the same with a home. So if you don't make your payments and you don't reaffirm, you're going to lose your home. Now, you could adopt the strategy of just continuing payments and not reaffirming in the hopes that the bank will just not take any further action, because after all, they're receiving their money every month. But it seems to me the drawback of that is if you got into difficulty a few years down the line and you had not reaffirmed your mortgage, it might be harder to take advantage of various programs or options to either modify the mortgage or reinstate the mortgage.
Although we have a comment from Mary Trainer who said specifically a client of hers discharged the mortgage in a Chapter 7 years ago, continued to pay voluntarily until they defaulted last year, and then they were recently received a Chase in-house modification with the HAMP language that the person has no personal liability for the modified loan, which is sort of a perfect outcome, I guess. We have several more questions. They kind of keep rolling in, Mark. Do you want to move forward a little bit, or do you want to keep going with the questions?
Yeah, just to comment on that, you could still get a, even if you don't reaffirm your mortgage, and this is in the HAMP manual, you can still potentially modify through HAMP after the discharge. That would be a possibility.
Okay. Let's see. I think a short answer here. How much time do they have to live in the home before it's taken after the mortgage is included in the bankruptcy?
Well, when a bankruptcy is filed, as soon as it's filed, the homeowner is protected by the automatic stay. The automatic stay is like an injunction. This is one of the really great features of bankruptcy. It's a massive restraining order against all of your creditors, preventing any of your creditors from taking any further action against you, well, with a couple of exceptions, unless they go to the bankruptcy judge for relief. So if you file a Chapter 7, for instance, let's say you've got a homeowner who's kind of going under, they can't make the payments any longer, there's no realistic chance for modification. They file the Chapter 7, what will probably happen is that the bank will make a motion for relief from the automatic stay. And then if that motion is granted, then the bank can proceed with the foreclosure. And you've got the same timetable as in a state court foreclosure. So in a Chapter 7, there usually, well, there will be like 3 different things that will happen. Number one, you'll file it for a client who's not really that far behind, but maybe having a host of other financial difficulties. Maybe the client's being garnished, for instance, or is just being overwhelmed by creditors. And so by filing the Chapter 7, you can put the client in a position where they can focus on making their mortgage payments. So that's one thing that could happen in a Chapter 7. A second thing that could happen is you file the Chapter 7 for someone who's just no longer has the income to make the mortgage payments and just wants to discharge the mortgage debt and their other debts and then get off to a new financial start. And then the third possibility is to file the Chapter 7, and while you're in Chapter 7, seek a modification. And then if the bank moves to vacate the automatic stay, you would counter by saying that you're seeking a modification of the mortgage. And for instance, if it's HAMP, you could cite the HAMP sync, the HAMP sections, which, or if it's Citibank, the various sections which say that those applications must be entertained even though you're in bankruptcy. And there's not been a lot of bankruptcy case law in New York on the right to seek modifications in bankruptcy, but there is some case law in other states. There's a recent case in Massachusetts where the debtor was trying to prevent a foreclosure, saying they had been wrongfully denied a HAMP application. They've been turned down without proper notice. And there the bankruptcy court said there's no private cause of action to enforce the HAMP rules, which is pretty standard. This is one of the problems we face in the mortgage foreclosure area. There's no private right of action against the various federal agencies that have issued mortgage modification regulations. But the bankruptcy court then went on to say there is a claim of violation of good faith and fair dealing. And so it basically established the same parameters that we have in our state court proceedings, saying that while we can't require a modification, we can enforce a good faith standard, and that good faith standard, in effect, incorporates your rights to a modification under existing programs. So those would be the three kind of options for someone facing foreclosure in Chapter 7.
So, Mark, we have about 7 questions coming in. I'm thinking that some of those questions are going to get answered in your materials, and we're already starting to run up against the clock. Maybe we can go through your slides and address some of them, and if we, depending on how much time we have, we can go through the other questions.
Oh, okay. So just very quickly, the advantages of bankruptcy are the automatic stay, which brings immediate, even if temporary, relief to your client, and the availability of comprehensive relief, that is, addressing the overall financial picture of your client and giving the client the capacity to focus on mortgage payments. I mean, we're all familiar with the statistics of large number of mortgage modifications down the road ending up in default. And one of the reasons for that may be that the homeowners are struggling with other financial problems that could be relieved to a great extent in bankruptcy. So that's one of the huge advantages of bankruptcy. Now, there are disadvantages also. There's the expense that you have to go through a private attorney. There's also a lot of scrutiny of the financial affairs of the homeowner. And so it's just not appropriate for everyone. For homeowners who are like working under the table or who transferred property to relatives or who may have a lot of non-exempt assets, bankruptcy may not be a good road to go down. And just continuing a little bit on how Chapter 7s work, I think I'll just kind of, skipping ahead a little bit, mention just a little bit about the Chapter 7 procedure. There is a requirement of credit counseling before you can file bankruptcy. And you would begin the bankruptcy procedure by gathering financial information, usually doing a judgment search, getting a credit report. There are a lot of schedules and itemizations to fill out, and we've referenced some of these in our materials. There's a filing fee, $306, so that can be waived for homeowners who are under 125% of poverty. And then the bankruptcy is filed electronically. You need to have all of your information and documents gathered before you file, because after you file, initially there are very strict deadlines on sending additional information to the Chapter 7 trustee. The Chapter 7 trustee is an attorney who works under the supervision of the bankruptcy court, who will be responsible for reviewing the filing, and who will also be in charge of a hearing, which is called a 341 meeting, to review the bankruptcy filing. In a Chapter 7, this is usually the only hearing that you will have. And in that hearing, the Chapter 7 trustee's responsibility is to try to find non-exempt assets that can be used to pay off the creditors in part. So when you're filing a Chapter 7 proceeding, you need to think through whether your client is best off with federal exemptions or state exemptions. Under bankruptcy law, you now have that choice. And very broadly speaking, under federal exemptions, there's a relatively small homestead exemption. It's around $21,000 per person. But there's a very generous $10,000 plus wild card exemption, which will protect a lot of your clients' miscellaneous assets. By contrast, if you choose state law exemptions, the homestead exemption upstate is $75,000 per person. It's $125,000 in Albany County and several other counties, and it goes up to, I believe, $150,000 towards New York City in the metropolitan area. But the downside of claiming the homestead exemption in claiming state court proceedings is that your client may be very vulnerable to being nickeled and dimed by the Chapter 7 trustee if they have miscellaneous small assets. So that's something that needs to be thought through. And then if all goes well in the bankruptcy, you traditionally make what's called a 522 motion, which is a motion to discharge liens, judgment liens. If they're judgments against your clients, those are liens against the home. And that's also a way sometimes of facilitating a modification if the lender is requiring cancellation of the judgment liens as a condition of the modification. And then you get a discharge order, and the bankruptcy case is closed. One of the big advantages of a Chapter 7 bankruptcy, if you have a client who is no longer seeking to keep the home, is that the discharge of the liability for the home is not a taxable event. It would not be considered gross income. Otherwise, there are possible problems. There's a general rule that forgiveness of debt is considered income. There's exceptions. It's in the same provision now if that's related to purchase money in a mortgage. But if the mortgage is more complicated than that and includes non-purchase money, there may be some tax issues. But the general rule is in bankruptcy, anything that's discharged is not considered gross income and is forgiven. So that's kind of rushing through Chapter 7. And I'd now like to talk a little bit about Chapter 13. In contrast to Chapter 7, which typically takes just 3 or 4 months, a Chapter 13 revolves around a repayment plan. And the repayment plan is typically 5 years. And the kind of typical Chapter 13 would be a client who fell behind in their mortgage. Maybe they owe a year or 2 on their mortgage, but they've stabilized financially, and they're now in a position to pay off the arrears if they're only given enough time, and they really want to keep their home. the way Chapter 13 works is a plan is proposed, and the plan has 2 or 3 different components. One would be over this 5-year, 60-month period to pay off the mortgage arrears. And then that's one component. The second component would be to pay a percentage of your unsecured debt. Very often this would just be 10%. And then thirdly, there are various other tools that can be used in Chapter 13, which can then become part of your plan. And these revolve around the notion of cram down. For instance, for car loans, if you have a car that is over 2.5 years old, or the loan is over 2.5 years old, you can do what's cramming down the obligation to pay the car to the value of the car, and then classifying the balance as an unsecured loan. So for instance, if the car is only worth $4,000 and you owe $10,000 on the loan, you can pay off that $4,000 over a 60-month period in your Chapter 13 plan, and then that $6,000 balance becomes an unsecured loan which can be paid off at only 10% or whatever is approved for your plan. The same cram down can be used for second mortgages in cases where when the second mortgage was obtained, there was no equity in the house. So let's say you had a first mortgage of $70,000 and the house was only worth $65,000, and you somehow got a second mortgage. And when you got that second mortgage, there was no equity in the house after looking at the first mortgage. That second mortgage can be considered in Chapter 13 an unsecured debt. It can be treated as an unsecured debt in the Chapter 13 plan and discharged that way. So Chapter 13 is a terrific way of saving a home for a client who has a regular source of income. And one of the really great features of a Chapter 13, especially for a homeowner who's been kind of struggling for maybe a couple years, not making any payments, is that things begin immediately. Under Chapter 13, the debtor is required to, within 30 days, resume payments to the bank going forward. And then once the Chapter 13 plan is approved, makes payments to the trustee over a 60-month period. And typically, those payments are by wage order. So they come out automatically from the homeowner or debtor's wages. And we've had a number of very successful Chapter 13s where people who struggled for a couple years, once they got into a Chapter 13 plan, even people of relatively limited means, thanks to the comprehensive relief of bankruptcy, they were able to make their payments to the trustee, typically through a wage order, and then resume their monthly payments. So that's the basic feature of a Chapter 13. And maybe I should just pause for a moment to see if there are any questions.
Well, Mark, we have quite a few questions, and I was actually just trying to look through your slides. I'm thinking that if you could maybe skip to like slide 13 or so, we have some really good, I think, very practical questions that would be good to answer. The one where you have mortgage claims and litigation, and then sort of what's best, bankruptcy proceeding or state court.
Oh, okay.
And I apologize for you through like that.
Yeah, let me talk about how the modification or litigation process can play out in Chapter 7 or Chapter 13. I think I'll start with Chapter 13 because that's more traditionally where this is played out. The Chapter 13 is filed, bringing the foreclosure to a halt. And I should say the Chapter 13 can be filed anytime up until the gavel falls on the foreclosure auction, and it will still bring the foreclosure to a temporary halt. Though as a practical matter, you have to get credit counseling, and you'd need at least a week or two to get your papers together to file. But at any rate, the debtor gets the automatic stay, which brings things to a halt. Now, if the bank wants to resume the foreclosure, the bank has to make a motion to lift the automatic stay. And at that point, the debtor can defend against that motion by taking the position that they have filed a Chapter 13 plan which will cure the arrears. And the bank will need to file a claim in order to get any payments under the Chapter 13 plan. The claim has to itemize interest, fees, everything that's involved in the overall amount that the bank claims is due. And that claim can be objected to. It can be objected to either in the form of objections in motion practice, or it can be objected to by bringing what's called an adversary proceeding. And an adversary proceeding is litigation in a Chapter 13. It's basically a federal court proceeding while the Chapter 13 is pending. It starts like a federal court proceeding with a summons and complaint, and then there has to be an answer, and then there's pretrial discovery, and then there's settlement conferences. So what could the adversary proceeding be about? Well, it could be about a variety of things. It could be about being wrongfully denied a mortgage modification. It could be about the claim of the bank being excessive or based on not having standing to bring a foreclosure in the first instance. As part of the claim that a bank files, it must file the note in the mortgage and any assignments of the mortgage. So those could be challenged in either an adversary proceeding or motion practice. And one of the advantages of doing that in bankruptcy, as opposed to the state court settlement conference, is that you have pretrial discovery, and nothing will go forward until your questions about the modification process are answered, or your questions about the assignment process, or your challenge to the amount of the claim is resolved. As long as you've got a good faith claim, those claims have to be resolved before the foreclosure can go forward. So that's the kind of rhythm of claims and defenses in bankruptcy. Now, in Chapter 7, Chapter 7 is supposed to end in 4 months. But in a Chapter 7, a debtor can also file an adversary proceeding. And then it will be up to the court to determine whether the automatic stay should be lifted to permit the bank to foreclose, or whether the adversary proceeding should be resolved. I had one Chapter 7 in which we had very strong defenses related to HOPP, the Truth in Lending Act, and the right to rescind. And in that case, even though it was Chapter 7, the bankruptcy judge, and this was a very conservative bankruptcy judge, put the whole case on hold while the adversary proceeding was being resolved. And it ended up in a settlement which allowed the client to keep their home. So let me pause again for questions. Are there any more questions? I think I've been cut off.
Oh, no.
Let's see. Yeah, there are a couple of questions here, Mark. This is Michelle.
Oh, okay, sure.
Sorry, I was on mute. My apologies.
Okay.
Yes, Mark, we have quite a few questions, so I guess that's my question for you is how do you want to handle it? Because we've probably got about 10 questions, which will take up more than the remaining 15 minutes.
Okay.
Well,
why don't you take what you think would be questions maybe of somewhat general interest?
Okay, so very good. So I think let's start with a couple of the I think, easy questions. Let's see. Do you have to be current in your mortgage payments before you can reaffirm the debt?
I would say yes.
Okay. You would say yes, or is that a requirement?
Well, I just don't think the bank would accept the reaffirmation unless you're current.
Well, I think that's an interesting question because I know that the banks frequently, when the homeowners are delinquent already, they require you to reaffirm it. I mean, this is what their claim is, right? That they require you to reaffirm it before you can enter into a modification, which obviously you're reaffirming it when you're delinquent already.
Yes, and I think that's backwards. I think if you filed in bankruptcy, under most cases, the bank should deal with the modification while you're in bankruptcy. And then when it's modified, you reaffirm.
But let's say that you've filed a modification, or you filed the bankruptcy, and now years later you're seeking a modification after the fact.
Oh, okay. I mean, that's what had been asked before. And I think there's a provision in the HAMP manual that says even though you discharged your mortgage in bankruptcy, you are eligible for HAMP. So at least as far as HAMP goes.
Okay.
there should not be a requirement that you reaffirm.
Here's another question then. If a person filed a Chapter 7 bankruptcy 3 years ago and is now being faced with foreclosure, can they file a Chapter 13 as a protection?
Yes, they should be able to. Now, they will not be able to discharge all of their debts necessarily, but they should have the protection of the automatic stay.
Okay. How will he said 552 motion, I think that's a typo, 552 motion work against a DSS lien? Is that supposed to be a 322?
Well, I think the way a 522 motion works is that a home in bankruptcy is a protected asset if it's exempt. And if there's judgments against a home, well, if they're judgments which are filed in the county clerk's office, that's considered to impair the exemption. And that gives the bankruptcy court the jurisdiction, the authority to cancel those judgments. That's what a 522 motion is. And I'm just not positive whether or not that would apply to a DSS lien or not. I just don't think I can answer that. I mean, a judgment is, I think, a little bit different than a DSS lien, but I would think it would at least be a possibility in a 522 motion. I mean, it would probably be worth a try.
Okay. All right. I lost. I think the answer is straightforward. Can a judge do a cram down of a first mortgage when it is severely underwater, and then their follow-up is, does it actually happen?
Well, that's a very good question, and unfortunately, the answer is no. When solutions to the mortgage foreclosure crisis were being considered, one of the suggestions was to give bankruptcy judges the option to cram down underwater mortgages. And that would have made a huge difference. Would have given lenders a tremendous incentive to negotiate with homeowners for fear of being dragged into bankruptcy court and having these underwater mortgages crammed down. So the answer is no. There's, with some limitations, naturally. A bankruptcy judge cannot cram down a mortgage. A couple of the limitations are a mobile home, which is truly mobile. You can cram down to the actual value of the mobile home. Or if the property includes, it's like a duplex and there's rental income, that can be crammed down. Now, there is one sort of major area which is still pretty much unexplored, though there have been some recent bankruptcy cases on this, at least one of which is cited in the slides. And that is, it's not really a cram down, but FHA mortgages and notes. The standard FHA mortgage and note contains a provision which says that foreclosure and acceleration is subject to HUD regulations and FHA loss mitigation procedures. And so there are now bankruptcy cases which say that since that is part of the mortgage under standard contract law, that is an enforceable obligation of the lender. And so if you're in bankruptcy through an adversary proceeding, you could establish potentially as a matter of right and not just as a matter of good faith that you're entitled to an FHA modification.
Let's see. Can you explain, let me ask the second part of the question first. Is a HELOC treated the same as a second mortgage, which I think is straightforward?
A HELOC? Yeah, the HELOC would be a home equity line of credit. And I think generally those are credit lines that people have obtained after they've obtained a first mortgage.
Although sometimes it can be a piggyback. So frequently,
yeah.
I think a lot of folks are seeing that the home equity lines of credit, many of them came from the old beneficial household days as well, where they did these piggyback first lien mortgage and a second lien line of credit, which were...
Yes, that was a very common feature.
And they were always over the value of the home.
Right. And so what you would have to show in order to get that crammed down in a Chapter 13 is that the first mortgage absorbed all of the equity. And then when you got the HELOC or the second mortgage, even if it was just seconds later, there was no longer any equity in the home. And so that it's technically unsecured. And so it could be subject to being thrown into the unsecured debt pool in a Chapter 13 where the lender's typically only getting 10%. There might be a real issue on the value of the house when you got that loan. I mean, that would be a great case where there was an appraiser who overappraised the value of the home, and the home was obviously not worth as much as the first mortgage. But
so,
that's...
Mark, what matters then is that at the time of origination, whether there was value at the time of the origination of the
yes.
second lien mortgage?
Yes, and like many bankruptcy rules and traditions, it's a strict all or nothing occasion. I mean, if you're $1 underwater when that second mortgage came on, if you can establish that, then that second mortgage can be crammed down as unsecured.
All right. Can you explain the difference between how stripping the loan is different from a cram down? Is there a difference?
I don't believe so, no.
Okay. There seems to be a lot of questions about the reaffirmation and how that plays into
how that's handled. You know, maybe what I'll do is if I wrote up something on that, do you think that could be circulated?
Absolutely. I think that would be quite helpful.
Okay.
I know that's always an issue.
Yeah, I think I'll do that. Just before we run out of time totally, I just wanted to make a pitch for legal services lawyers considering admission to bankruptcy court. Legal services lawyers are among the best of the lawyers in New York State in being conscientious and promoting law reform. And if you look at bankruptcy case law in New York, there's just this absence of good legal services litigators establishing great case law and using the terrific potential of bankruptcy. So it's something that really should be considered. I mean, bankruptcy is just an enormously powerful remedy for poor people or people of limited means. And it definitely is not for everybody. There are many advantages of just going through the modification process, getting your loan modified, and then maybe going into bankruptcy and canceling your other debts. But there are other cases where you can help stabilize someone long-term. You can challenge the bank's practices in a variety of areas, and bankruptcy is very suitable to that.
All right, so we're running out of time now. I want to be respectful of people's time. Mark, we have a list of questions that I'm wondering if we can address in a couple of different ways maybe. Number one, perhaps you can go through these questions and provide some sort of a response to the ones that seem the most appropriate to provide something like that, if that's okay.
Yes. No, if you want, if we have all the questions, I'd be glad to respond to all of them.
Great. And then the other part that I am tentatively going to volunteer you for, Mark, and I apologize in advance, is if people have specific questions about bankruptcy and how it might impact their clients, is there a way that they can get some of those questions answered from you?
Well, I'd be glad to give it my best shot. I have to say, far and away the most qualified legal services bankruptcy practitioners, John Rayo of the National Consumer Law Center. And my bankruptcy practice, by comparison, has been much more limited. It's also limited to Western New York. I mean, one thing I just wanted to mention was that in the Southern District, there's this outstanding plan for debtors who are seeking modifications and are in bankruptcy. And there's a whole set of procedures. You can go before a referee, and there's special forms where you're seeking loss mitigation in bankruptcy. I mean, all of it is just like a model for handling bankruptcy and loan modification at the same time. But at any rate, the resources now they're somewhat limited. NCLC is a terrific manual, but John Rayo is just too tied up to answer individual questions. There's a bankruptcy project in New York City, I think, which could probably be very helpful, and Jay Inwald could probably put people in touch with that for people in the city or the metropolitan area where bankruptcy practice will have very distinctive features. But at any rate, I'd be more than glad to try to answer any questions that are forwarded to me.
Okay, great. Thank you. Michelle, I believe we have a CLE code that we have to announce.
Yes, the CLE code was also given in the chat box, but I'll announce it verbally. It's 9145A as in Adam. That's 9145A.
Okay, thank you so much, Mark, for providing this session. There's clearly a lot of questions about how bankruptcy can impact our clients in foreclosure. Perhaps that's a signal to me that we might need a Bankruptcy 201 webinar down the road. But nonetheless, I appreciate everybody's time. I hope this was helpful for folks, and have a nice rest of the day. Thank you, Mark.
Okay, thanks a lot, Becky.